very good evening to all of you friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So friends, in this session, I'm going to talk about the most important legal developments that took place in the month of April 2023. So, in the month of April, what were the most important news, legal news, that a student who is preparing for a law entrance examination like CLAT, ALIT, SLAT, Maharashtra CET, Jamia, be that as it may, each and every one of you should be aware of? These are the important developments that took place in the month of April 2023. So guys, without much ado, let's begin. But before we begin, I want to say certain very important things. Now, we are discussing legal current affairs, monthly legal current affairs. And the most important legal news is what I'm going to discuss with you during the course of this session. Okay, so I want each and every one of you to have a pen and a piece of paper in your hand so that when I discuss certain things, you can jot it down. Okay, so guys, let's begin. But before we begin, BYJU'S Exam Prep brings to you a free workshop on strategies to ace the NLU call in CLAT 2024. This workshop is going to be conducted by Alpa Sharma on the 21st of May at 6 p.m. So hurry up and register now for this free workshop on strategies to ace the NLU call in CLAT 2024. Moving on, BYJU'S Exam Prep brings to you a CLAT 2024 comprehensive course. Now in this course, we are providing you with 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mock tests for CLAT and other law exam along with video solutions, monthly e-magazine on current affairs, and the entire content is based on our understanding, our research, and our analysis of the last 5 years of CLAT question paper. So hurry up and register for this comprehensive course. BYJU'S Exam Prep also brings to you a scholarship test. Get up to 90% scholarship on our preparation program. This scholarship test is scheduled on 28th of May at 11 a.m. So hurry up and register now for this scholarship test so that you can get up to 90% scholarship on our preparation program. So guys, moving on. The top important legal news. Afzal Ansari, the brother of ex-MLA Mukhtar Ansari, has been convicted of a particular offense under various offenses under the Gangster Act by a special court in Ghazipur. So he was convicted of certain criminal offense under the Gangster Act. He has been sentenced to 4 years of imprisonment. Now what happens then? Now, he is a member of the Lok Sabha. Now, under the law of the land, if a person, same thing happened to Rahul Gandhi. Now, if a person is convicted of an offense, whether he has appealed or not, unless and until there is a stay of the conviction, he is disqualified from being a member of the Lok Sabha or Rajya Sabha. Now, so here is a sitting MLA. Now, many people are imprisoned for 4 years. So why is this news so important? This news is important because here is a situation which is akin to what Mr. Rahul Gandhi is today faced with. He has been given a particular sentence by the courts in Gujarat relating to certain statement that he made against the Prime Minister and others, calling Modi that surname, the Modi surname defamation case. Now, similarly over here, an individual, a particular individual, a particular member of the Lok Sabha also lost his membership because he stands convicted by a court of law. Now, under Article 102 of the Indian Constitution, read with the Representation of People's Act of 1951, Mr. Ansari, same thing goes with Rahul Gandhi. They stand disqualified from being a member of the House. Now, here is a case against Mr. Ansari that he was involved in the kidnapping and murder of two individuals. One was kidnapping of the Vishwa Hindu Parishad's office bearer, Nand Kishore Rungta, and the murder of BJP MLA Krishnanand Rai in 2005. So these were the two cases that were against him. The Uttar Pradesh court has held that this particular individual is guilty. He has given imprisonment. Now, since he is a member of the Lok Sabha, he loses his Lok Sabha seat. Very, very important. Am I clear? Very important news, guys. He lost his seat owing to this particular event. Am I clear, everyone? Okay, moving on to the next important news. On the occasion of the birth anniversary of B.R. Ambedkar, Justice Gawai of the Supreme Court of India recounted Dr. B.R. Ambedkar's contribution both as an educationist, as a sociologist, as a lawyer, as well as the chief architect of the Indian Constitution. Now, here was a man who had created or framed the Indian Constitution. Now, on his 132nd birth anniversary, sitting judge of the Supreme Court, Justice B.R. Gawai, said a number of things about this great luminary. And that great luminary is Dr. B.R. Ambedkar. He said that he did not feel shy. Who? Dr. B.R. Ambedkar did not feel shy of speaking about the background of the framing of the Indian Constitution, which had preceded the history of the fight for Indian independence. It also preceded the fight for social and economic equality by the millions of people who were deprived of their basic rights. And therefore, he said that with all our castes and creed, it shall be very difficult. It shall be very difficult to unite all the people. He was making a reference with regards to the boycott by the Muslim League of the proceedings of the Constituent Assembly. And he said that we must make an attempt to bring back the Muslim League in the main frame and frame of our Indian Constitution, which will be acceptable to all and all, including the Muslim League. So here was a giant figure. It's a giant figure. Dr. B.R. Ambedkar, he had great qualities. Although he had faced discrimination because he belonged to the lower section of the society, the backward classes. Although Dr. B.R. Ambedkar belonged to the backward classes, he rose up the ladder and became the chief architect. He was the architect of the Indian Constitution. Now, he was a chairman. He was not only the chairman of the Constituent, the drafting committee of the Constituent Assembly, but he also was the first law minister of India. So I'm sure that you guys are aware of it. Dr. B.R. Ambedkar was the first law minister of India. Now, of course, another very recent news. I think yesterday only we have a new law minister, right? In the chat box, I want you to give me the name of the law minister of India, Union Law Minister of India. Okay, a hint: he is from Rajasthan. Okay, he's from Rajasthan. So yeah. So Justice B.R. Gawai was making a very important statement regarding the contributions that were made by Dr. B.R. Ambedkar on the occasion of his birth anniversary. It would be relevant to refer Dr. Ambedkar's speech on 4th of November 1948 in the Constituent Assembly while presenting the final draft of the Indian Constitution. He refers to the history of Constitution and the Constituent Assembly, the meetings of the various committees. The first draft prepared by B.N. Rao. Thereafter, the final draft, and subsequently he placed various provisions of the Constitution which had been finalized by the drafting committee for consideration of the Constituent Assembly. So here was a man whose immense work insofar as the Indian Constitution is concerned, is irreplaceable. We cannot have another Dr. Ambedkar because there cannot be another Dr. B.R. Ambedkar. He was one of the greatest of his times, and he was much ahead of times. Now, if you see the Indian Constitution, the various provisions of the Indian Constitution, you can see how far-sighted he was. Is that clear? Moving on to the next important news from the month of April. The Supreme Court has asked CBI, ED to maintain status quo insofar as the investigation onto the West Bengal municipality recruitment scam is concerned. Now, the Supreme Court has said that CBI, Enforcement Directorate, whatever you have done, whatever investigation you have conducted insofar as the West Bengal municipality recruitment scam is concerned, you have done. Do not do anything more, do not do anything less. Wait for further orders. So the Supreme Court has given an order of status quo insofar as the investigation of the municipality recruitment scam is concerned. The Supreme Court passed this direction after considering the fact that the Calcutta High Court directed the CBI investigation in the matter without hearing the state of West Bengal. Now, it's a very basic principle of law that when a judge is passing a judgment, he has to give opportunity to both the sides. Now, the Calcutta High Court, without hearing the government, the state of West Bengal, passed this direction directing CBI to investigate into this municipality recruitment scam. The Supreme Court said that in the interest of justice, we are of the view that it would be appropriate if the state of West Bengal is heard. Very, very important. That is what the Supreme Court categorically said. It would be appropriate if the state of West Bengal is heard afresh by the High Court on the issue as to whether the investigation should be initiated by the CBI. We accordingly permit the petitioners to move a petition by way of review before the High Court. The High Court shall, after hearing the parties, take a considerate view in this matter. So, because the Calcutta High Court did not hear the state of West Bengal, the Supreme Court directed the Calcutta High Court to hear the state of West Bengal and then decide whether this case is a fit case for a CBI inquiry or not. Now, the Calcutta High Court order, that is the impugned order that was challenged, was passed taking note of the Enforcement Directorate's finding in the probe into the teaching recruitment scam. The genesis of the scam was revealed after dealing with education matters relating to primary school. Now, various things. Now, there is a teaching recruitment scam. There is also various scams. Now, just because a particular scam took place in the state of West Bengal doesn't mean that everything is a scam. That is what the Calcutta High Court, and it's a very good order from the Supreme Court directing the Calcutta High Court to hear the state of West Bengal, hear the other party before directing anything. Moving on. The Chief Justice of India, as you know, Dr. D.Y. Chandrachud, is a man of internet. Now, we are in the age of internet where live streaming is a very important aspect. Now, I am right now live streaming. So, I'm live right now. I can see you guys. Right. Now, the Chief Justice of India, who happens to be a very tech-savvy person, has said that there would be live streaming of court proceeding across India. So, a virtual inauguration ceremony of two IT projects of the Delhi High Court, namely the digital courts for contested traffic challans and bail orders sharing module on e-prison platform. So there are two important projects: digital courts for traffic challan. So you right now, if there is a traffic challan, you don't have to go to the courts. It's all done by the digital courts. Bail orders are to be uploaded and given in the e-prison platform. So there are certain things that are going on, and I'm sure that the Chief Justice of India has a great vision insofar as live streaming of court proceedings across India is concerned. He said that it is important to reach out to the citizens. It is important to reach out to the citizens by ensuring live streaming of court proceedings. The same will be launched shortly across the country. He further added that live streaming, citizens can truly understand the nature of the work that judges do and the quality of input which goes into judicial proceedings. Now, unlike Lok Sabha, Rajya Sabha, where there are disruptions, people are fighting, in the court it does not happen. I'm sure most of you have seen court proceedings by now, right? So that's a very important thing, and I think that the Chief Justice has done a tremendous job. The entire Supreme Court is to be lauded for this great thing. The Chief Justice said that live streaming has already been adopted in several courts. In the Supreme Court, we have been ensuring live streaming in the Constitution Bench hearing, and one thing which I have heard across the country during my travels is the uniform statement of everyone that live streaming is important hearing by the Supreme Court has truly enabled the country a large to understand the seriousness with which work is rendered by our judiciary. Now, unless and until the people of the country get to understand what judges really do, how will people have faith in the judiciary? So, to have faith in the judiciary, there should be accountability, there should be transparency, and no closed door thing. Now, if a citizen sitting in Kerala wants to know what is happening in the Supreme Court, what option does he have? Does he have the option of flying to Delhi? No. He wants to see whether the judges are performing their duty or not, because at the end of the day, it is the democracy, it is the people, it is we the people who are at the fountainhead. Everyone is serving the country. And very recently, one very important thing, e-SCR, e-Supreme Court records have been launched, wherein 34,000 judgments of the Supreme Court are available free of charge to all citizens who wish to access those judgments. So 34,000 judgments have been uploaded. Now the country is going, now there is virtual hearing. We are also teaching virtually. The classes are happening online. So similarly, it is high time that e-courts continue to work. Next up, the government of Karnataka tells the Supreme Court that reservation based solely on religion is unconstitutional. Now, the Karnataka government had this particular policy of 4% reservation to Muslim people in the state of Karnataka. So in the state of Karnataka, there was a 4% reservation to Muslim people in government jobs, in schools, everywhere. Now, just before the election of Karnataka, the government decided to scrap this policy. So the government was planning to scrap the 4% reservation which is provided to Muslims. Now, the Karnataka government says that this scrapping of the 4% reservation to Muslim is absolutely perfect because reservation in India, now I'll tell you the gist, because the government says, the Karnataka government says that reservation based on caste is valid, but reservation based on religion is not valid. It is unconstitutional. You cannot have a reservation solely on the basis of a particular religion. The Karnataka government also added that such reservation not only violates the mandate of equality, Article 14, 15, 16 of the Indian Constitution, but also violates principles of social justice and secularism. Now, everyone is to be treated equally, irrespective of their religion, place of birth, language they speak, color of the skin, whatever. So why should, that's the point of the government. Let's see what the Supreme Court decides. And I'm sure that since there is a change in the government in Karnataka, this particular case will go to the cold storage soon, because the present government might not decide. The court had to decide whether reservation based on religion can be done or not. The answer is, the Karnataka government says, no, you cannot have reservation based on religion. You can have it on other things. The Karnataka government in its affidavit said that the aim of reservation as envisaged in the Constitution is to promote social justice by providing affirmative action to those who have historically been marginalized and discriminated. So the reason for reservation is because certain group of people had been historically marginalized, discriminated. For them, this scope of reservation was brought. The same has been enshrined under 14 to 16 of the Indian Constitution. The backward classes have been referred as a collection of certain classes by none less than Dr. B.R. Ambedkar himself. So, backward classes means collection of certain classes. The whole point being here, were socially and educationally backward classes in the society who have been historically deprived, discriminated. The same cannot be equated with an entire religion. Now, you cannot, just because there are 10 people in a particular religion who have been discriminated, does not mean that everyone can get a reservation of that religion. Now, reservation practically should be given to those who have stood discrimination, who have gone through deprivation against the society. Now, it cannot be given to everyone belonging to a particular religion. Finally, the Supreme Court of India says allopathy doctors and Ayurvedic doctors are not entitled to equal pay. Now, allopathy doctors and Ayurvedic doctors, they might be performing a particular job. Now, in a hospital, there might be Ayurvedic doctors, there might be allopathic doctors. Now, can tomorrow someone say that every doctor, whether you are allopathic doctor or Ayurvedic doctor, you should have equal salary, equal pay? No. Now, I'll give you an example. Now, can all doctors, now somebody is an Ayurvedic doctor and somebody is a heart specialist, can you have equal pay? No, that's a wrong point. The court was concerned with the question, the Supreme Court was concerned with the question whether different scales of pay can be fixed for officers appointed to the same cadre on the basis of education qualification possessed by them, by holding that the issue is no longer res integra. And the classification, very, very important, the classification based on educational qualification is not violative of Article 14 and 16 of the Indian Constitution. So the Supreme Court says there can be different pay for an Ayurvedic doctor and a different pay for an allopathic doctor. And finally, in the month of April, the Supreme Court said that irretrievable breakdown of marriage comes within the term cruelty. A marital relationship which has only become more bitter, acrimonious over the years does nothing but inflicts cruelty on both the sides. To keep the facade of this broken marriage alive would be doing injustice to both the parties. Now, if two people are fighting, they have a bitter relationship. Now, if you do not give divorce to them, if court do not give divorce to them, that means the court is doing injustice to both the parties, the husband as well as the wife. The Supreme Court said that a marriage which has broken down irretrievably, in our opinion, smells cruelty to both the parties. In such a relationship, each party is treating the other with cruelty. It is therefore a ground for dissolution of marriage under the Hindu Marriage Act, under section 13(1) IA of the Hindu Marriage Act. Now, very, very important, if a marriage has broken, let people part off. If the court interjects and says, no, you cannot leave this relationship, the court is doing injustice. Court finally concluded that long separation and absence of cohabitation and the complete breakdown of all meaningful bonds and the existence of bitterness between two has to be read as cruelty under the Hindu Marriage Act. So if there is a long separation, absence of cohabitation, complete breakdown of all meaningful bonds, it is an end of marriage, and court should generally grant divorce under those circumstances. So guys, these were some of the very, very important legal events that took place in the month of April 2023. And all those of you who are watching me live, if you liked it, do press the like button. BYJU'S Exam Prep brings to you a CLAT 2024 comprehensive course wherein we are providing you with 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mock tests, both including CLAT and non-CLAT, monthly e-magazine for current affairs, and the entire content is based on our extensive analysis of the last 5 years of CLAT question paper. Hurry up and register now. BYJU'S Exam Prep brings to you a free workshop on strategies to ace the NLU call in CLAT 2024. 21st of May, 6 p.m. by Alpa Sharma ma'am. Register now. And finally, if you liked this session, do press the like button. Do subscribe to our YouTube channel. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S Exam Prep app. That's all from me now. Have a great weekend. Bye-bye. Thank you. All the best. Bye-bye.